Hello and welcome to the program. I am Imoni Amarere. On Friday, February 25th, 2022, President Buhari finally assented to the much-awaited Electoral Act Amendment Bill, thus repealing the Electoral Act 2010. The journey to this stage has been a long one. The bill suffered protracted delays and setbacks both in the legislature and from the presidency, resulting in about 8 rejections between 2015 and 2021. It took the collective pressure of Nigerians for the act to see the light of day. The new act, according to President Buhari, comes with salient provisions that could positively revolutionize elections in Nigeria and guarantee the constitutional rights of citizens to vote and engender clarity, effectiveness, and transparency of the election process. However, before signing the bill, President Buhari expressed reservations about a specific provision of the bill. He has misgivings about Section 84, subsection 12, which precludes political appointees from being delegates at political party congresses and conventions for the purpose of the nomination of candidates for any election, where it holds earlier than 30 days to the election. In other words, political appointees cannot vote or be voted for at party congresses or conventions unless they have resigned their positions prior to the congresses and conventions. He therefore requested the National Assembly to amend the provision by expunging it completely from the Act.
My perspective that the substance of the bill is both informative and progressive. I am making this bold declaration because I foresee the great potentials of the bill. Worthy of note include the democratic efficacy of the bill with particular reference to Sections 3, Section 9, subsection 2, Section 34, Section 41, Section 47, Section 84, subsection 9, 10, and 11, among others. This, however, cannot be said about one provision as contained in the proposed bill, which provision constitutes fundamental defect, as it is in conflict with extant constitutional provisions. Section 84, subsection 12, constitutes a disenfranchisement of serving political office holders from voting or being voted for at conventions or congresses of any political party for the purpose of the nomination of candidates for any election in cases where it holds earlier than 30 days to the national election. The section provides as follows. No political appointee at any level shall be voting delegate or be voted for at the convention or congress of any political party for the purpose of the nomination of candidates for any election. This provision has introduced qualification and disqualification criteria that alter various the Constitution by way of imposing blanket restriction and disqualification to serving political office holders, of which they are constitutionally accorded protection. The practical application of Section 84, subsection 12 of the Electoral Bill 2022 will, if assented to by operation of law, subject serving political office holders to inhibitions and restrictions referred to under Section 40 and 42 of the 1999 Constitution as amended. It is imperative to note that the only constitutional expectation placed on serving political office holders that qualify by extension as public officers within the context of the Constitution is resignation, withdrawal or retirement at least 30 days before the date of the election. Hence, it will be stretching things beyond the constitutional limit to import extraneous restriction into the Constitution on account of practical application of Section 8(4), subsection 12 of the bill, where political parties, conventions, and Congress, Section 12 of the bill, where political parties, conventions, and congresses were to hold earlier than 30 days.
Right, there have been quick responses to the president's observations and requests, both for and against. Some say it is an attempt by the president to protect political appointees and perpetuate the current order where they overwhelm the political process. Others say the provision contravenes the right to vote and be voted for. Now, is the president's reservation justified, going by the 1999 Constitution? Now, a civil society coalition is already asking the National Assembly not to yield to the president's pressure to delete the provision. According to the group, the session will not only improve the voting process, but would have a positive impact on governance, as it will put a stop to the reckless use of state resources for personal political pursuits. They also argue that it would make for a level playing field for all contestants, as it would deny political appointees the usual influence and appearances of office to ride roughshod over their fellow contenders. But besides, political office holders like state governors are known to bloat the number of their political appointees to gain electoral advantage at party nomination congresses. Now, so we will be looking at these requests by Mr. President against, of course, another provision of the Electoral Act which mandates political parties to hold their primaries long before elections. And if time permits us, we shall also do a sneak preview, or review, of course, of the INEC timetable released over the weekend following the signing of the Electoral Bill into law. We will meet our guest analyst right after now. Stay with us. Thank you so much for staying with us. Let's get to meet our guest analysts, two of them who are right here in the studio with us in person. First, from my far right is Ezenwa Nwagu. Ezenwa is a board member of Yaga Africa and chairman partners for electoral reforms. Thank you so much for joining us.
Thank you.
Also joining us is Victor Gewa. Victor Gewa is a lawyer and he is the national coordinator, Advocates for People's Rights and Justice. Victor Gewa, thank you so much.
Thank you for having me.
Great. So we now have a new Electoral Act after so many years of struggle. First, what would be your immediate response to the president's decision to sign the bill into law?
Well, like I joined several Nigerians to appreciate the president. Like I said in one of your sister programs on Saturday, I have really expected the president to assent to any amendment that is to be done to the Electoral Act, because the president has been a victim of some of those issues that are being raised. and that are proposed to be amended, having contested election. Like a friend of mine, we say that he has been a serial contestant of the presidential election. And so he has gotten to a case where even in, well, that was 2002, where he had a split vote, 4-3, where the Supreme Court said that the election was marred with irregularities, and 4 others said that it was, although there were irregularities, but they were not substantial enough to change the narrative of the vote. So I expected that the president would be very fast in assenting to any electoral act that will ensure, and in using his word in the speech, that will reduce the acrimony that will always come out from electoral processes. So it's a good thing. I thank the president, and of course I expected, I was just surprised that he had to have a lot of, he has to hold his assent for more than 8 times, like you said, before the final passage of this one.
Was it worth it? The long wait, was it worth it? If you look at the provisions contained in the act now, do you think it was worth it?
Well, it's worth it because, first of all, this new amendment has brought in some new innovation in the lexicon of our political process. We have seen, for example, a timeline within which INEC should be funded under Section 3. We saw the use of officially, it has been legislated, electronic transmission of votes. We have also seen the power of INEC under Section 54 to look at results when it is gotten under duress. We have also seen certain provisions, the right of the people with disability. We have seen the jurisdiction of the Federal High Court. We have seen situations where, so there have been a lot of innovations which Nigerians have been campaigning for. But I need to put this caveat that it is not El Dorado. This is not a perfect electoral process. And like I said again in one of your sister programs, the problem of Nigerians have never been the law. It has always been the operators of the law. Like I said, we have had an amendment of the Electoral Act. Let us have the amendment of the minds of the politicians so that they can work according to the rules. That have been the problem. And Justice Oputa, in various decisions, have said, we don't have problem with our laws. We have always had problem with the people who operate the laws.
Governor Ezenwa, what would you say are the highlights of this act for you now? I mean, given the very many years that we have been on in the trenches, advocating and fighting for a new electoral law, which of course is expected to bet a new electoral system.
The big issue for me will be financial independence for INEC. And the reason I say that is that the challenge that we have had with logistics is predicated on the fact that you have vendor inefficiency, and sometimes, if you like, not getting the resource that they need to provision for electoral materials on time. And the challenge that poses for us is huge in terms of even the psychology of postponing elections and the trauma that brings about. So if we have financial independence, where the resources, the money they need to finance election is given to them 1 year, according to this new law, that may help us overcome issues around punctuality, issues around movements and the rest of them. That's critical. Another important thing for me is the issue of contravention by INEC officials of the law itself, which is now punishable under this new act. So if you've been in the field, you would see, for instance, that many of the times that we cry about the failure of the innovations that we have introduced, it has not really been majorly as a result of those innovations. It has had to do with this sabotage and subterfuge and collusion by politically exposed persons and certain even elements within the electoral management body. So when these laws come the way, these 10 new introductions into this law, the issue of people living with disabilities, the issue of making a call under duress, and the possibility of review that is now available in this new law, which means that you can't get a result through option AK-47 like we have seen in some states where people even sit today in Senate and say, look, the politicians would be like, do whatever you like, just go to court and let's go and sort it out in court. Now, the possibility of that review can bring some relief for people who are agitated over outcomes of elections. So we are looking to a new horizon, but this caveat is always very important. And the reason to continue to signal that it is because the big issue is that the politicians have, once you make a new law, they go to the laboratory. They put everything you have brought out into a lab and begin to work to subvert it. And so if you have a political class that absent themselves from conversations around electoral integrity, even when you have these beautiful sunshine laws that we are excited about right now, we may not have the outcomes that we eventually want if we don't do the necessary advocacy. And like Victor said, we have to now do some real work with the politicians themselves. Because Moni, you know, I've said it here often, we over-respect them. We have respected them to the point where we don't take the issues to them. We oversight INEC in a suffocating manner. We oversight security agencies, but the politicians, their candidates, we respect them. And they are at the center of everything we are talking about, these laws. They are the ones who induce, who want to, even the INEC officials themselves, they are the ones who bring thugs to the place. They have vicarious responsibility for all the challenges you see around the election issues. Yet, in all our conversations, we leave them out and then face the electoral management body and the rest of them. So the new law is important, but we need to now push advocacy to the political parties and their candidates, and also to the judiciary. Because these two playing together have become the reason why our election is not as, electoral process is not as exciting as a lot of citizens will want it to be.
Talking about sunshine provisions, one of the sunshine provisions in this act is Section 50 of the act that deals with, that gives INEC the legal backing for electronic transmission of results. And you know that this was one issue that was harped on by civil society, by many Nigerians over time. And in 2019, before, during, and after the 2019 elections, it was a major issue, even at the tribunal, where there was talk of an election server existing somewhere, and references were made to it here and there. Now, with this Section 50, which gives INEC the legal backing for electronic transmission, would there now be a server, an INEC server somewhere where these results will be transmitted to? Because these are some of the issues.
I think there is a lot of confusion about what we have currently. What we have is a bimodal. Bi meaning that you still have manual working side by side, electronic. So you are just improving the integrity of the process. So what does it mean? It simply means that you post result electronically real time to, you know, from the polling unit to probably whatever INEC would decide that is. It could be server, it could be whatever it is. But even the beaver itself has storage capacities. From what we have been told, it has storage capacities and the rest of them. But all of this is just a way of bringing trust to the electoral process, where people, because the challenge has always been at the polling unit. And you know, Victor, we used to say that the weakest link is collation.
Exactly.
So this law is curing that that problem, that misdemeanor in the polling unit, where between the polling unit and the transmission of results, things are altered. So now you have a two-way to follow this process, electronically and manually. And we saw some good tests of it in Ondo, in Edo, you know, and it really increased
confidence,
you know, citizen confidence in the process. But like I keep saying, this technology, we cannot surrender our whole electoral process to technology. We must also work on those who operate this technology to give us the. So what do you have? You have smart card readers, you have beavers and the rest of them. And if you followed what happened in Anambra and what happened in the FCT, you will agree with me that there needs to be much more attention to those who operate it rather than that machine.
And even what happened during the by-elections
yes,
2 days ago, yes.
Yes, so it's important. I, for one, have always held the view, and I push it everywhere I can, that there is not much challenge with the innovations. In many circumstances, what you see is collusion. Community collusion, political exposed persons working with very, you know, some electoral officials to ensure that those things don't work, so that they can create emergencies. And when they create those emergencies, they can then pervert the process with the agreement of everybody. You know, it's a different thing when you come to a place and the beaver is not working and everybody within the system says it's working. You can't do much about that. So this education, this voter civic education around this new law is as important as the law that has been passed. We need to invest in it to make sure that everybody, the politicians, their political parties, their candidates, and the judiciary understand these new laws in a way that can give us the outcomes that we're looking for.
Especially where, like everyone says, the politicians are themselves by now already beginning to plot how to subvert some provisions of this law.
Exactly.
So what exactly do we need to do? And when I say we're talking of the media, civil society, INEC itself, and the political parties themselves, who are supposed to be the main organs of political education.
Yeah, like he has said, part of it is enlightenment, civil education, political education, like what you are doing right now. We are talking about the innovations in the Electoral Act. Nigerians need to be educated. They need to be informed about these provisions, how the provision applies to them, how it cures some of this fear. Of course, the whole excess of the amendment is to cure some of the fear that have been expressed by Nigerians, but has been expressed by the citizens, but have been expressed by stakeholders. So one of the ways we can see that this particular law, like I said, although it's not perfect, but is to ensure that, first of all, we educate Nigerians, including the politicians. Like I said, we don't need to exclude them. Everybody, you'll be at one point or the other, you are a politician, or you will join the political community at a point. But people need to know these provisions, people to know that it is going to be punitive if there's a violation of the law. And the judiciary, secondly, the officers of the court, the judicial officers, they need to be schooled, they need to be trained about this innovation. But the good thing about it is the fact that the Electoral Act has captured those innovations, talking about the electronic transmission, talking about the technology. Because what we saw in the case of Abia State, this Abgar candidate, was that after they got the result, he won in the Court of Appeal. But in the Supreme Court said the card reader was not recognized under the Electoral Act. But what this Electoral Act has done is to capture the provision, show it in the law that, yes, the use of technology has been captured. It is now a law, so it is not just enough in INEC guideline. Because one of the major challenges we've had before is that there have been a lot of reliance on the INEC guidelines. And when there is a conflict between the INEC guideline and the Electoral Act, the Electoral Act will prevail over the INEC guideline. The INEC guideline made provision for the card reader and all of that, but it was not contained in the Electoral Act 2010. But now what the Electoral Act 2020 has done is to, first of all, is to bring that legislation that there is now something called, the technology, electronic transmission, and there are technological devices that have been adopted by INEC for the purpose of the electoral process. So that has now been recognized. So the judicial officer will take judicial notice of these devices. So I was just thinking this morning that I think INEC should also organize a lot of workshops for the court officer, for the Court of Appeal, for the Federal Court officers, and for the Supreme Court, so that they can understand some of this innovation, so that they can, when the cases are brought before them, they can have enough information to know the slant between what we have in the Electoral Act and the provision of the various Supreme Court decisions. Because it is very easy for people to say, oh, you quote a particular Supreme Court decision to say there was nothing like electronic transmission or electronic voting, but that provision, that laws, right now, by the passage of this Electoral Act 2020, certain decisions of the Supreme Court will not be applicable because those decisions were based on the Electoral Act of 2010. So you cannot cite an authority of the Supreme Court within this angle of the Electoral Act 2022. So people need to know, and the Supreme Court themselves need to know that they cannot, because we are bound by judicial precedent in the judiciary, but they should know that the precedent is based on the individual facts and the law. So how can INEC ensure that if this information are brought to the courts, to the judicial officer, is very key. It's one of the ways to ensure that this Electoral Act gets the necessary attention, the necessary understanding it needs, so that we don't have some of these issues that we had before the Electoral Act was passed.
Now, let's now look at what the president said before signing the Electoral Act and his request, which is that Section 84, subsection 12 of the Act as it is now, seem to contradict or contravene certain portions of the Nigerian Constitution. And that, of course, that provision says that if you are a political appointee, now let's distinguish between a political appointee and an elected political office holder. This act specifically refers to political appointees, that they cannot participate in a party primary to determine or choose candidates for an election if they do not resign 3 months prior to that Congress or convention. The president seemed to disagree with that, and he says, please expunge it from these acts.
You see, I've always maintained that President Muhammadu Buhari is not Fidel Castro. Neither is he Nelson Mandela. He's an establishment politician, establishment person.
Doesn't want to ruffle any feathers.
So, but why are we pushing for reforms? We are pushing for reforms because there are certain misdemeanors that we have seen. Those misdemeanors is what we are hoping that our law will help us to cure. So when we have a president who is defending, holding very tenaciously to a system that we have seen that has not helped us, even from a ethical perspective, though not law, but ethical, ethical politics. What do I mean by that? You sit in an appointed position, and this is wide, because I got some education earlier today. Vice chancellors, chief medical directors, all of these people also come, if you want to make a definition now of political appointees. So you need to have spread this dragnet. But what is the issue? You sit somewhere, you use the apparatus, the platform of that your office, and get dubious advantage. So that dubious advantage has created an uneven playing ground for people in what should be a contest.
That is even
a competition. But my worry is that the National Assembly need to spread it But they are not going to do that because we need to, this dichotomy between political appointee and elected official has a deeper implication because one fits the other. The appointer fits the appointee. And then you say the appointee should remain and use private jets paid for by public expense while he is contesting as a governor. He will not resign.
As a minister.
As a minister, no, as a minister can resign because he's a political
appointee. Yes.
But if you didn't have, if you have an incumbent president
or a senator
or a senator, they will all sit there, use those positions, use security agencies the way they want. So we will push. What we are doing is that we are going to keep pushing. We may not get everything we want in one whole hog. Something can be rejected today, but tomorrow we get it. The National Assembly should take a deeper, reflective look at that Section 84 and drag in everything that has to come into it before it can take a decision.
So your position is that rather than expunge it as the president is requesting, it should actually be expanded.
It should be expanded
and properly defined.
Yes, because the appointer fits the appointee. If for instance, I am a minister, for me to take due advantage of that office, I have to get the support of my principal in real sense. If I don't do that, my principal can call me to order. So the man who has the bigger responsibility is sitting pretty well and asking, you understand? And even the National Assembly themselves, who inserted that surreptitiously, because it's important to point that out. The one they brought before that we are challenging didn't have this provision.
Yes.
It didn't have this provision.
They brought it.
It was during the amendment. So you see lawmaking that is always holding to his side, that is constantly thinking of his own advantage, thinking of how to dispossess other people and take advantage and protect himself. So we need to make laws that are statesmanly, that look beyond us, that cover the territory. Because those of us who are pushing for level playing ground, the advantage is that, like Victor said, sometimes there can be a transition. You can sit down now. Many of them who are opposed to local government autonomy today, as governors. They start as governors and protected that autonomy, refused that autonomy. They have become senators now. They are now asking for autonomy. For local government. So we must make laws that, because these transitions, when it takes place, it may work for all of us without any prejudice. So the big challenge for me is that the big issue about our lawmaking is that it has never been one in which we are taking the public interest and public good collectively as our view. It is always about us, what advantage it can give to us, and once it can give an advantage to us, we reject it, we play it back, and that's why you have this thing about a good National Assembly and a bad president who is rejecting the bill. The president rejects bill 8 times. How did the National Assembly contribute in that rejection? No, that conversation does not come into the fore. You only say, oh, he has rejected the bill. But if you have those issues that civil society raised, for instance, what do you call them now? That they cleaned out in this one. They first denied it, that there was no cross-referencing errors. There was no cross-referencing errors, and then they came back and agreed that
it was inserted that
and all of those things. So we need to have more serious lawmaking engagement than we are having. We have a National Assembly that can make law, and you see shillings, Kenyan shillings in those laws. And so the resources, the outcome, the service delivery outcomes that we get from the National Assembly put up vis-a-vis the kind of resources that we put into that place, 5 special assistants for a House of Rep member, and all of that, and we still get this kind of mistakes, needs to be talked about. We need to put it in the public domain so that every time there is a refusal for assent, we don't just say, he has refused assent. The real issues that he raises are important, because one issue, one single is, Victor can attest more to that, shall and
may
may become a problem for the law that you have put out. So we had to beg this president now to say, please assent, so that we don't throw the baby with the bathwater. There are sunshine innovations in this law that if you reject it again, it will be a huge setback for us. Send it back to the National Assembly. But what you see in that is that it is more of a territorial control thing in lawmaking rather than public good and public interest.
All right, Victor.
Yes,
we will look at that in more details.
Yes.
And we will also look at the possibility of what Eze has talked about now. That is, if it's possible to criminalize some of these issues. For instance, the issue of, say, a senator, a member of House of Rep, or a governor using public resources to fund and carry out their campaigns, as is done in some other democratic climes, rather than possibly having it in the broadening this aspect of the act now and bringing all of them on board, but maybe criminalizing it might be an option when we return. All right, welcome back. Victor, in the United States, where we borrowed the presidential system of government from, it's a criminal offense for any public office holder to resort to the use of public resources, even as small as a government car, to enhance his or her campaigns while seeking re-election, for instance. Now, is it not possible here to make a law specifically criminalizing such an attitude in order to prevent political office holders like governors, like senators, like members of House of Reps, and even the president, as Ezenwa pointed out earlier, criminalizing such acts rather than maybe expanding Section 84, subsection 12, as it is today?
Okay, well, it is possible, and it's also recommendable. Now, because you see, like he said, the politics is a game that should be given on an equal playing field. If I've not occupied any political office before, I should not be placed at a disadvantaged position from somebody who has occupied and is still holding the office. Of course, that contest will not be an even one. So in other climes, like you mentioned, in the United States, it is criminalized. You can also use state fund, state resources to pursue your own individual political ambition. So it is expected that when you are going to, prosecute your political ambition individually, you use your state resources. But there's something I need to highlight, and that is what I think the president misconstrued. And I was looking at when the president signed that assented to that to the act, whether the Attorney General was there, because his comment was to the fact that Section 84, subsection 12 of the Electoral Act that he has assented to is in conflict with Section 40 and Section 42 of the Constitution, but that is not actually the fact. Now, first of all, let us look at Section 40. Section 40 talks about freedom of association, that everybody has the right to associate, to belong to any association, political party, and club. And so that Section 84:12 does not, as it is, preclude anybody. It did not say that they should not belong to a political party. It just said that they cannot vote for a delegate or be voted for in any convention or congress. But let me tell you where the misconception came from. Now, Section 166, subsection 1, paragraph F, and Section 137, subsection 1, paragraph G, talks about disqualification of public officer, and says that, for example, for the purpose of the president, a person is disqualified if within 30 days to the election, a person being a person employed by the public service or the civil service of a federation or of a state. So the president is saying that the qualification given under Section 84 for political appointee is what the Constitution has provided for. So in that case, he has missed the difference between an appointee and a public officer. An appointee, a minister, a special advisor, are not public officer under Section 318 of the Constitution and Section Schedule 5 of the 5th schedule of the Constitution. So he was saying that, oh, that section is in conflict because, no, that section talks about a public officer employed. And for the purpose of political office, a public officer is anybody that is employed by the civil or public service of the federation of this or of the state. So a minister, a special advisor does not fall under public officer. So the president was confusing that oh, what you are saying is a
special advisor and all the other
they are not public officers.
Many creations of governors and presidents,
yes,
and do not fall under that category.
And so there is a mischief, like Eze said, that section intends to cure. Or of course, it's to cure the fact that you cannot be using state resources to sponsor. What happens if that's what we call the mischief rule under the canon of interpretation? You will see a situation where when political parties are having their conventions, ministers we charter jets, we use public vehicles to convey delegates, take them to hotels with state fund. And that section is saying if you must participate in any convention, please resign. That is just what he's saying. And it is never in conflict with Section 40. And Section 42 of the Constitution talks about discrimination on the basis of ethnicity, basis of race, on the basis of sex, and religion. That is not what Section 8412 is saying. He just saying, look, my friend, if you are so much interested, resign your office. You resign from your office as a minister or as a special advisor, as a commissioner. And I think to me, I think the president so what Eze is saying is just extended. That includes people who are elected. And those people who are elected to don't form part of public officers. So they can as well, that section can also apply to them. So the major part I'm trying to emphasize is that the president misconstrued that section to mean because he said it is already provided in the Constitution and Section 40. No, you can be a political party. That is not a problem. But at the point where you want to canvass for vote for the purpose of any office, or you want to be voted for, he's saying resign. I think to me that is a game changer for all of us, to ensure transparency, to ensure accountability, and to ensure that there is fairness in the political process.
You see, when you have a pool of vested interests, that's the big challenge. You have people who are in political office who want to use that political office for advantage.
So you intimidate.
And they are already circling the president. It's just that we're in public.
Which is in line with the question that I'm going to ask. I mean, for an administration and for a president that has one of his major mantras as anti-corruption, shouldn't this be an opportunity to actually say, look, this is what it should be?
You see, I keep making this point that until you understand that you are dealing with an establishment politician and not a revolutionary politician, you will never be able to answer this question that you are asking. See, the Constitution, the mantranization of anti-corruption itself is neither here nor there, because the Constitution compels you to abolish corruption. So you are not in any serious way inventing anything.
Any new way at all?
No, it's part of this thing that Nigeria runs into every time. The 7-point agenda of President Yar'Adua, the transformation agenda of President Goodluck Jonathan. And so when you see a politician wants to talk, before he starts, he will say, in line with the transformation agenda, in line with the anti-corruption. All those things are cliches that mean nothing. In practical terms, we need to revolutionize our politics. We need to get people who are ethical in orientation, who are reformers in thinking. So until that happens, when you are dealing with a politician, don't mistake him for a priest in terms of order, rituals. He is always looking, the politician is always looking for advantage. And even today, the president is more interested, if you look at this Section 84 that he's so angry about, you will find out that it is more political than, you know, for
than
public
legal.
interest
Yes.
than legal. It's more about, so if we divest this power, the governors will come to convention as every other person.
Without any advantage.
And the National Assembly is interested in that because the attrition level for the National Assembly has been high, and they are pointing always to the governors for why they are not returning. Okay, so they inserted that when we gave a push around the issue of indirect and
direct primaries. This was their hit back.
It's a hit back, and all of us know these issues. So the president and the governors moved very swiftly to even stop. You saw the governor from Southeast. He was on television saying the president cannot sign if he doesn't want to sign.
Yes,
all of those issues. So the vested interest showed their face. They manifested themselves very clearly, and they are saying, if you take this power away from us, how do we, you know, control this thing that has become? They have hijacked the political parties. The executives take over the political parties, both financing and control and administration. So if you have a law that tends to want to take those powers away, they kick back.
And there is no limit to the number of political appointees that they can appoint.
Exactly. They want to tell the president the number that he can make, but in their own state they can appoint 1,000.
SAPA.
They help the president to appoint minister. They help the president to appoint commissioner in different places. They bring nominees from their states, but nobody controls what they do so it's about control. It's about but what will those of us who act in public interest do? We must continue to push. We might not get everything we want. It's always very important. It's a democracy. Those interests, they have a right as well to push their interests.
Yes.
But our work is to galvanize citizens in the way we have galvanized them and push to this point where we can get an Onochie rejected by the Senate. We can get the laws, you know, the president to give assent even when he... So it is civic engagement that brings that about. If we stay aloof, we continue to complain, and we don't engage and participate. So today we have had these few gains, 10 new important insertions into our electoral law. That's a victory. In the next few years, this one it can also be achieved, and that is the value of democracy. That we continue to push, we continue to get citizens to engage and push to that point where we get the outcomes that we are looking for.
Victor, let's be very clear here, because some interpretations or misinterpretations have been given to this provision of 84(12). Does it necessarily undermine the rights of political appointees to hold office and participate in?
No, that's what I just said. No, it just says that if you want to enjoy a vote and be voted for the purpose of political office, can you imagine that a minister who wants to contest as a president or as a governor, he comes into a convention with his ministerial paraphernalia. He goes into, he details, he comes with his police, he comes with his security. Not just only does he participate in the police, he intimidates his other opponents. So that section, it is just in line with cleaning the system, making sure that the system is transparent and accountable, that it is participatory, that I don't want to go into a contest and apart from looking for votes, I'm going to be fighting somebody who has guns, who can push me out of the hall, who can block,
who has obscene money,
who have too much money, who have a state fund, not his own personal fund. So that system is saying no. Within 30 days, because within that period, you don't have access to some of these things. You don't have access to this security aids you have with you, so that you can go into the contest with everybody on a neutral basis, and the contest becomes even. So it did not in any way derogate from their power. It just said, no, you cannot be voted for, or you cannot vote for anybody. You must resign within 30 days to that convention for political congress and conventions. So I think to them it is something they should applaud if they are really going to political contest to, to get the votes of the people without causing any form of intimidation.
So what can be done at this point in time to avoid or push back on the pressures that Ezenwa talked about that will be mounted on the lawmakers at the National Assembly to want to expunge this session or amend it to suit whoever interest?
Yeah, but sincerely, I don't really see the national members of the National Assembly amending that section. Because like I said, it is the request of the president is based on how he misconstrue that provision based on the section he cited. Two, if you expand it, it will be for selfish reasons because, I don't see the president coming to contest as a senator again. There's no history of any president coming back as a senator. We have seen governors coming back as senators and all of that. But so I think that instead of expunging it, I believe if these facts are brought to the knowledge of the president will take a different position. Like I said,
who will bring the facts to the
Attorney General, of course, should be able to bring that section 40. That section.
That is if the Attorney General himself was not the architect of this.
If he's not, of course, some people like
yes.
him, we are going to be the direct beneficiary of some of what he just mentioned. Because right now he is a minister. So what that section is saying is that he should resign his position
if he intends to. Yes.
Yeah, so he may be very fast to say, oh, we need to amend that section. But however, if the president wants to ensure transparency like he has always canvassed, corruption-free system, reduce the acrimony, like he said in his speech, an electoral act, he said it is reformative and progressive. I think that the president should be silent. We should allow that section to remain and see what comes out in the other.
So everyone will be your message to our lawmakers.
They should, that insertion is a selfish insertion from my own point of view for the National Assembly. They also should expand it to include them. That for them to sit down, they cannot sit in National Assembly, go and contest election with all the benefits that accrue from that, and then hope that there is another person who should resign. It does not, that is the conflict that we are seeing. Okay? And so once you have that situation, we are going to have a situation where they are not going to take one step. And that pushback can have challenges in terms of how we even implement the one that has been passed. Because their role stops as lawmaking, this other person's role is implementation. If that harmonization doesn't take place in terms of conflict, in terms of the interest that is at play, we may have a challenge. My call, as I have said, is expand it. If you are not expanding it, throw it away.
Yeah, but one of the things I need to say is that the reason why people like elected officers might not be included is because their tenure they have a tenured period. It is either you are for 4 years or you are for 5 years.
There is no,
but for the minister and the special advisors, it is not a tenure.
No, the minister doesn't even have a tenure. If the president, if the appointer,
they should resign.
No, if the appointer wakes up, from the wrong side of the bed,
he can dispense with his duties.
Yes.
So that is the reason why he's so.
No, the elected cannot be asked to resign because his position is tenured.
No, because if he's tenured and he wants to now contest, because his contest is not tenured. His contest is self-serving. He can say, I have done one term and I'm going.
All right, gentlemen, thank you so much. Thank you. We're out of time. I want to thank you immensely for coming on the program. Ezenwa Nwagu, board member, Yaga Africa, chairman, partners for electoral reforms. Thank you so much for your time. And Victor Gewa, lawyer and national coordinator, advocates for people's rights and justice. Thank you so much, gentlemen.
Thank you for having us.
For coming on the program. For you, our viewers out there, I want to thank you for investing your time with us. Please join us again when we bring you a fresh edition of the program.